Good afternoon. On behalf of the Office of Juvenile Justice and Delinquency Prevention, I would like to welcome you to today's webinar, Legal Challenges to Medical Testimony. My name is Callie Murray, and I am with OJJDP's National Training and Technical Assistance Center. As your technical host, I would like to take a couple of minutes to discuss a few features of Adobe Connect, which will help you maximize your opportunity to participate in today's webinar. To download a copy of the PowerPoint slides and other pertinent handouts, locate the Handouts pod directly above the chat area. Click on the name of the file, then click the Download button. To send a chat message, type your message into the chat box. Hit Enter or click the message bubble icon to send. For those of you participating in today's webinar as a group, please take a minute and help us count. Go to the chat window and type in the total number of additional people in the room with you today. This will help us with our final count. Again, if you are viewing with a larger group, please type in the number of additional people joining you today. If you are viewing by yourself, there is no need to type anything at this time. At the conclusion of today's webinar, you'll be provided with a link to take a 5-minute online survey about today's presentation. We appreciate your feedback regarding this webinar. This information is used to assist in future planning and training. You will be able to access an evaluation link on the last slide of the PowerPoint, and it will also pop up in a browser window at the webinar's conclusion. Finally, this event will be archived on OJJDP's online university in approximately 3 weeks. Again, thank you for joining us today. I'll now turn it over to your moderator, Jason Allen.
Good afternoon. I'm Jason Allen. I'm a staff attorney at the National District Attorneys Association. NDAA is the largest and oldest nonprofit organization funded to help America's prosecutors and allied professionals. We have many programs targeted to assist prosecutors in specific areas, such as child abuse, traffic, white-collar crimes, and violence against women, to name a few. NDAA has 3 main missions. These are to provide world-class technical assistance to prosecutors and allied professionals on the investigation and prosecution of crime, to provide state-of-the-science trainings and education on all areas of criminal investigation and prosecution, and to represent the voice of America's prosecutors on Capitol Hill. You can visit our website at ndaa.org to see how we can help you, as well as download many of our free publications. Today we have a webinar presented by Sasha Rutizer and Dr. Jennifer Markowitz on legal challenges to medical testimony. At the conclusion of the webinar, participants will be able to describe the types of objections to forensic nursing testimony, discuss the ways in which nursing and medical foundations assist in providing objective testimony at trial, and analyze the medical hearsay exception to better understand the legal underpinnings that shape forensic nursing testimony related to patient statements. Dr. Jennifer Markowitz is a forensic nursing consultant, writer, curriculum developer, and educator. She received her clinical doctorate in nursing from the University of Colorado Health Sciences Center and is board certified as a women's health nurse practitioner and sexual assault nurse examiner adolescent adult. You can find her at her website, Forensic Healthcare Online at forensichealth.com, or on Twitter under the handle @ForensicHealth. Sasha Rutizer is a senior attorney at the National District Attorneys Association's National Center for Prosecution of Child Abuse. She has over 12 years of experience litigating special victims cases as a prosecutor, defense attorney, and government appellate attorney. At this point, I'll turn it over to Sasha and Dr. Markowitz for their presentation.
Okay, good afternoon, everybody. Thank you so much. There's well over 150 people online right now, and we really want to take a moment to thank you for taking time out of your day to spend some time with us. Thanks, everyone, for being here. All right, so as I'm pulling this up, Callie or Jason, can you let me know if that is populated?
I don't have it yet, Sasha.
All right, how about now?
There we go.
Great. Okay, great. So first off, we just want to give a special thanks to our colleague and friend, Jennifer Pierce-Weeks. She's contributed a great deal to this presentation. So, Jen and I have taught for a number of years on the effective use of courtroom testimony by sex assault nurse examiners and other medical professionals. And what that basically did was teach how to communicate what you know, saw, or did in a way that educates juries. But all of that presupposes that the judge allows your testimony in the first place. And I know I've got a number of prosecutors on here as well. So this session is going to cover what happens when there's an objection to your testimony, either in whole or in part. So you can see we're really covering three of the major issues in pretrial litigation. And I say pretrial litigation because that's typically where you're going to see it, but it actually could happen right there in the middle of trial. So we're going to cover what are called Daubert hearings. We're going to spend the bulk of our time talking about Daubert hearings because they really are the most complex and least understood by both prosecutors, judges, and witnesses. And then we're going to move into hearsay, and then finally we'll spend some time talking about Crawford issues in the Sixth Amendment. So in any given case, a prosecutor typically is going to want four things. Now, not in all cases are they going to want all of these because, of course, it depends on the role of the medical expert. But if you're the treating clinician, then generally speaking, I, as a prosecutor, am going to want the following. I'm going to want the medical findings if there were any from you. I'm going to want to know the relevance of those findings or the relevance of the lack of findings. I'm going to probably also want to get your opinion on the causation of those findings. I may also want statements made by the patient to you, and in some cases I might want your opinion or information to educate the judge or the jury on what we routinely refer to as non-intuitive behaviors or counterintuitive behaviors. And it doesn't matter if you're a sex assault examiner, if you're doing a child physical abuse examination, if this is a domestic violence exam, or even an elder abuse or vulnerable adult examination. These are typically the four things that we're going to want from you. So anybody who's watched any legal movie, My Cousin Vinny, everybody who's ever heard me before knows this is my favorite teaching movie. And so if you've watched any of those, you know that this is an adversarial system, which means it's one side versus another side. And so when one side doesn't like what the other side is going to do or what the other side is going to say, they lodge an objection. And of course, the judge rules on that objection. He either agrees with the side who lodged the objection or he disagrees or she disagrees with that. So the way that it's typically going to work, and any of you who have testified before, you understand what happens, and that is a question is asked, and I'll default to me being the prosecutor. I ask you a question. Specifically, I want your opinion on something. And the defense doesn't want that opinion to come out. So they're going to lodge an objection. Objection, Your Honor, to this witness testifying about this particular issue. So that happens either in trial or it happens before trial. And that's called a motion in limine, pretrial pleadings, that type of stuff. And so that will usually come in the form of one of these three major objections. And that is that you are not qualified to give any opinion. We may see that because you are, according to the defense, just a nurse and you can't testify to diagnosis or differential diagnosis because you're not a physician. it may be in the form that you're not qualified to render this opinion. And that's because perhaps you're new to this particular field in the defense's opinion, or you just simply don't have the education. Because let's say for a moment that you have a bachelor's degree, but you don't have an advanced practice in nursing or some additional higher degree. And that's what the defense would be objecting to. And then finally, the objection that you might see is that the opinion that the prosecution wants from you is either improper, irrelevant, or unhelpful. All three of those, the prosecution has to overcome in order to get your testimony in. And Sasha, I think this is really one of those places where it's imperative for forensic nurses to really think about ourselves as more than just the work we do in forensic nursing. We have to be able to think of ourselves as fully formed clinicians, bringing to the table not just the work we've done as forensic nurses, but all of the other clinical work that we bring to the table as well. Because the possibility exists that you've only done a handful of sexual assault medical forensic exams, but if you've been working for the last 10 or 15 years in the emergency department, the reality is that you assess hundreds, if not thousands, of injuries, and all of that comes with you into the courtroom. It's important for that to be able to be articulated. And that's a really important point for the prosecutors who are also listening to this. Pretrial preparation with your medical expert, I beat that horse to death all the time. It really is critical, and you'll see that theme reappear throughout today's presentation. So let's dive in. Here's what we're going to talk about. We're going to talk about medical testimony in the courts, and basically I'm going to have a conversation with clinicians the same way I'd be having a conversation with law students or prosecutors, and that is the legal standards for admissibility. I think it's really important to teach that way because I think that there's so many times where you hear a prosecutor ask you a question, for instance, well, what was the demeanor of the patient? And you're like, I don't know, they were alert and oriented. What do you want from me? And that's because we didn't explain to you why the demeanor of that patient is so critical or relevant to a particular issue. Specifically, I'm referring to hearsay. Or if you hear me or Jen ever talk about knowing the science, it's because there are issues like a Daubert hearing or Rule 702 hearing that determine the admissibility of your testimony. And I think it is important to know the legal underpinnings of that. So that's what we're going to do. And you'll see me talk about Daubert, Frye, Joyner, Kumho-Tyrer. Those really are the four major cases that have impacted the general world of expert testimony. And then we're going to talk about hearsay and its limits. Most people on this phone call are familiar with something that we refer to as medical hearsay. We're going to specifically talk about what is and isn't medical hearsay, and then some additional hearsay exceptions that may come into play from the clinician treating the patient. And then finally, we're going to wrap up with a big issue, actually Jennifer's favorite constitutional amendment, which is the Fifth Amendment. But we're going to limit it to the confrontation clause in medical testimony. There's actually a really recent case that just came out of the Supreme Court that has changed, in my professional opinion, the landscape of Crawford. So it's important, I think, to mention that. So the first thing I want to talk about is the original case that got this whole thing started. If you are interested, those crazy numbers and letters that are right underneath the name of the case is actually the legal citation for where you could find the case. So if you were bored, you could, one, Google this, and if you're a prosecutor, you can pull this up on Lexis or Westlaw. So this is a case that came out of a D.C. Circuit Court. This is not even a Supreme Court case, but the D.C. Circuit Court is viewed by most of the legal population to be essentially a step below the Supreme Court, although procedurally it isn't. It's just in terms of esteem, it is. So this is a 1923 case, really old school. So the issue in this case was the defendant in this case was on trial for murder. He wanted to bring in what was the crude precursor to the polygraph. And this was basically based off of systolic blood pressure. So clearly he thought that he had passed this test, which is obviously why he wanted to bring it in. So the problem was, because this is 1923, and if anybody knows, even today in 2015, the actual lie detector tests are inadmissible. Polygraph examinations are still inadmissible today because they continue to fail Daubert. So in 1923, the systolic blood pressure detection test hadn't gained what in the D.C. Circuit Court opinions view was, it hadn't gained standing and scientific recognition among psychological and physiological authorities that it would justify the courts in admitting this expert testimony. So the problem at that point, it hadn't quite reached the general acceptance in the relevant scientific community to even come in. So you see down there in the bottom right-hand corner that I've got that word, that phrase, general acceptance, highlighted. And that's because from 1923 for the next, 50, 60 years, that was basically the law of the land, whether it was federal court or state court. And if you don't know, there's a difference between all of the states and the federal system in the way that they have their rules of evidence. Now, all states have their own rules, but by and large, they're pretty similar. And the federal system has its own set of rules. Although, again, by and large, over the years, most of the states are similar in terms of the federal system. But technically speaking, they are different. So the law of the land in the federal courts and the state courts was that in order to bring in testimony that was scientific in nature, it had to have gained general acceptance in that relevant field. And that actually was a pretty strict standard when you start to see what happens next. So in 1975, the federal rules of evidence were enacted. It's actually not that long ago. So before that, there actually was not a codified set of rules for what comes in and doesn't come in. But in 1975, that was. And so what happened was we get Rule 702. Now, you may have heard that in your state court, and that is because, generally speaking, states are similar to the federal rules. So you may have a Rule 702 that addresses expert testimony, and you can bet that it's based in part on the federal rules. So the federal rules came up with this rule of what is admissible for expert testimony. So what you see here is that a witness who's qualified as an expert based on their knowledge, their skill, their experience, training, or their education can give an opinion, and of course that's the difference between a regular fact witness and an expert witness. A fact witness is somebody who tells what they know, saw, did, or heard, where an expert witness is used to educate people on complex concepts and render an opinion. That's the main difference, it's opinion rendering. And so you get these 4 different subsets of criteria for what has to be proven in order for an expert witness to give testimony. So you see that it's got to be based on scientific, technical, or other specialized knowledge, and it has to help the jury understand something. That's basically called the relevance factor. It has to be relevant. And then B, C, and D go to this prong that I'm going to refer to often as reliability. And that is the reliability of the science that is going to be taught. Because if you go back to the Frye test, remember that's the solid blood pressure test, it had not yet gained general acceptance in the field. That is, it hadn't been tested enough to be considered valid science. So that's what we get from B, C, and D, is just these ideas of reliability. So that's Federal Rules of Evidence 702. So even though that came out in 1975, all the jurisdictions were still relying on this Frye test. The problem is that when the federal rules came into play, they quote unquote occupied the field for the federal system. That means everybody in the federal system should have stopped using the Frye test and should have started using this Rule 702, but they didn't. So that's where you get the Daubert case, and a Daubert hearing comes directly out of this case, and this is a 1993 case. So long story short, what happened in this case is a couple of children who had significant birth defects sued this pharmaceutical company, saying that their birth defects were caused from a drug that their mom took while pregnant with him. And so it started in state court, but the pharmaceutical company basically moved that case, or what's called removed that case from state court to federal court. And they did it very smartly, and here's why. They moved for summary judgment. Summary judgment means this shouldn't even go to trial because the plaintiffs can't prevail. And what they said was they can't prevail because there's no evidence that they can present that will support their claim that this drug causes negative impacts in humans. And so the Daubert folks said, no, we have these 8 experts, and these 8 experts are going to come in and testify that it is. Now, they're going to base it on a bunch of studies that are from animal testing, but they're going to be able to extrapolate that data to say that it impacts humans. And so what happened is the federal court said, no, we don't think you're there now. They were actually still citing the Frye standard. And so what happens is it gets affirmed on appeal, the summary judgment, and then it gets brought up to the Supreme Court. And so the Supreme Court, for the first time, gets to weigh in on the impact of the federal rules coming in. And so what we get a number of things. The first thing we get is the Supreme Court saying, listen, if you're in a federal court, you cannot use the Frye test. You have to use the federal rules of evidence. It did not say that to the states because this was a federal court issue. Now, in today's society, the vast majority of states use Daubert. There are I can't say many in any vast majority, but there are some states that still use Frye or a hybrid of Frye/Daubert. And so you'll just want to know what state you're in because generally speaking, Frye seems to be a little bit more restrictive than Daubert, and I'm going to tell you why. So in Daubert, the Supreme Court says, listen, Judge, instead of deferring to the scientific community on whether some science is valid or not, we're going to hold you responsible. You're the gatekeeper here for what evidence comes in and doesn't come in. And so judges now have to determine the scientific validity and reliability of this testimony. So the way that they do that is they gave 4 different criteria, but they were very clear to say that these 4 criteria that we're listing here, it's not an exhaustive list, it's not an exclusive list. It's just some stuff to consider because they reiterate the idea that allowing expert testimony should be liberal. Now, we have to be very clear that the judge's role as the gatekeeper is we're concerned with relevance and reliability. And that is because we're going to allow this witness to give an opinion to a bunch of people who don't know this science. That's why they're on our jury, because I wouldn't allow somebody on my jury who knew the science. So if we're going to allow somebody to give an opinion on the science, I want to be darn sure that it's reliable and valid science. So what they said was, and you'll see these 4 criteria anytime you do a Daubert hearing. And again, a Daubert hearing is generally going to happen prior to trial. So 1, is the theory or technique that you're going to testify about, has it been tested? Has that theory or technique been subjected to peer review and publication? Is there an error rate? Again, this speaks to the reliability of that particular science. And then the 4th criteria they give is, has it achieved general acceptance in the relevant community? Now, many of you are saying, hey, that's actually the same thing that Frye said. Very interesting that the Supreme Court took pains to not use the Frye test in here, yet they use language that seems to be kind of the same. But that's only 1 criteria, as opposed to it being the exclusive criteria that was in Frye. So you see that Daubert is a broader, more liberal standard than Frye, but we still are concerned with whether or not it's rogue science. So that's what you see here. So then we get another case just a few years down the road that set up, and this is generally for the prosecutors in the room, what the appellate review is going to be for a case where a judge determines admissibility of evidence. And that's called the abuse of discretion standard. And that is if a judge abuses his discretion, which is a pretty broad interpretation, it actually takes a lot of information to show that a judge abused his discretion. And then it reiterated the fact that there is a liberal thrust to admitting expert testimony, and courts shouldn't concern themselves with the conclusions reached by these scientists or these experts. Rather, we're interested in looking at the methodology and the principles behind the science. And there has to be a connection between the data and the opinion. And what you see here outlined in this crazy Latin word called the ipsi dixit, which is basically because I said so. We don't want anybody saying that this is my opinion based on this data because I said so. We need that reliability. So that's what you get from Joyner. And then rounding out these cases, we get Kumho-Tyre. So historically, Frye, Daubert, Joyner, that really all centered around scientific testimony. But what about all that other stuff, the non-scientific stuff? So what we got from Kumho-Tyre is the Supreme Court saying, Judge, you are responsible to be the gatekeeper for all of this information coming in, whether it's scientific or technical or based on specialized knowledge. And that's where we get the vast majority of expert testimony that is not, for instance, DNA or ballistics or tool marks or fingerprints. It's oftentimes what we refer to as the soft sciences. And so specifically for the sex assault nurse examiners or forensic examiners on this phone call, generally speaking, that's where this comes into play. And even things like differential diagnosis. So if we were doing an abusive head trauma case and we wanted to show that the subdural hematoma was caused by non-accidental injury, non-accidental trauma, that would still fit under this specialized knowledge, not necessarily scientific. So the other thing that we get out of Kumho-Tyre is that, listen, you can consider these specific Daubert factors if it helps in determining reliability, but the Supreme Court says those factors neither necessarily nor exclusively apply to all experts or in all types of cases. I say that because when we do a Daubert hearing, we start going through those 4 different criteria because that's what we got from the Supreme Court, and we're all sort of wedded to doing that, but we don't have to. They don't have to fit into those because there are many sciences that just don't fit, for instance, non-intuitive behavior. How could you get an error rate for counterintuitive, non-intuitive behavior? You can't. It doesn't fit in there. And so we have to be able to say to the judge, and clinicians, you may actually have to say to the prosecutor, look, it's a soft science. It doesn't have to fit directly in there.
Yeah, we're gonna actually demonstrate that in just a few slides. So we'll actually sort of walk you through what that looks like in just a bit.
So the interesting thing about Daubert, and I said that we're going to spend the bulk of our time on this, I said that because it's complex. And here's how we know it's complex. Not too long ago, there was a national survey done on judges and their understanding of Daubert. And I have it cited below. You're welcome to pull it up. In fact, I think I got it off of the Google search. I don't think you have to belong to any particular database in order to pull this up. But what happened was they surveyed a number of judges, and they wanted to understand if judges clearly could articulate these standards in Daubert. And so we get some alarming statistics for the first 2 of the 4 Daubert criteria. So the first thing that we talked about in Daubert is this, whether or not it has been tested, right? So whether the theory or technique can be tested and has been tested. So we also refer to that as falsifiability, meaning have other people tried to test this theory and proven or disproven or criticized it? So what we did was, look, 88% of the judges surveyed thought that was a useful tool in considering the admissibility of evidence. The problem was that 94% of them couldn't articulate a true understanding of what that meant in the scientific arena. Stated differently, 6% of them could state a clear understanding of this. The second issue that we had was this error rate, because we're concerned with reliability. So the error rate, we get 91% of them say, you know what, that's useful in considering whether or not I should admit this into evidence. The problem is that a whopping 96% of those judges couldn't articulate a clear understanding of what that meant. And 86% of them, their responses revealed that their understanding of it was, and I think they're being nice here, questionable at best. We get a little better under peer review and publication in general acceptance criteria, so I don't really need to spend time on that. I only bring this study up because I want you to know that prosecutors don't necessarily understand it a whole lot better, but judges definitely don't understand it. We know that from this study, which means that it's critical that we have really good pretrial motions, and in our motions we're describing the science, because that's the time that the judge is going to actually read it. In the actual Daubert hearing, all I want us to do is dot the I's and cross the T's. But in the pretrial motion, we're going to have to sit down with whoever our expert witness is, and we have to get smart on the science of this and write that out there. And that is going to allow the judge enough time to go over it. So that's why I say what it means for us. We just can't assume that the judge or the prosecutor is going to necessarily know anything about the science. So this is where I think it's really important that we are not brief in our motions. Rather, we err on the side of over-inclusion, and we maybe append the actual science to the motion so the judge has it. So one other note, because I don't know where better to put this particular slide, but it's important that I actually have it in there. Prosecutors, when we're tendering our experts, we have to be very specific about what field we're offering them for so that they can give an opinion on that. So list all of the fields you think that they're qualified in. And if you can't articulate in your own brain what that means, ask the expert. Say, hey, listen, I want you to testify about this, this, and this. What do you think I would generally qualify you as an expert in?
Great. So, before we get into really walking through that whole process of the Daubert hearing and doing a little bit of demonstration, I do want to talk about some of the foundational aspects of it. Because I think in order to effectively testify as an expert nurse clinician, you do need to be able to couch your testimony in the foundational aspects of the profession. And this means being able to speak to the definition of nursing and its basic components as the building blocks of the work that we do. So in this section, we're going to go ahead and examine those basic components that allow sexual assault nurse examiners to establish our credentials as expert clinicians and not just as evidence technicians, which will enhance our ability to testify to expert opinions and other aspects of the medical forensic examination. It may be challenged, such as hearsay statements, which we're going to go ahead and discuss later on in the session. So the first thing that I do want to talk about is really the definition of what nursing practice is. And for those of you who've heard me talk about this issue before, this is always going to be the first thing that I put up here, because I think that this is such an elegant definition of nursing. And this comes from the American Nurses Association, from the Nursing Social Policy Statement. And if you read it, it has this really beautiful language. It's the protection, promotion, and optimization of health and abilities, prevention of illness and injury, alleviation of suffering through the diagnosis and treatment of the human response, and advocacy in the care of individuals, families, communities, and populations. And one of the reasons why I love this definition so much is because it does incorporate some of those key terms that are critical to our work as it's introduced in court and is often misunderstood, specifically those terms, diagnosis and treatment. People frequently state, and I'm going to go ahead and include nurses in this group, people frequently state that nurses can't diagnose, and yet the American Nurses Association clearly states within this definition that the very concept of nursing includes diagnosis and treatment. So it's important to be able to bring out when educating judges, and frankly when you're talking with with prosecutors who are calling you, to be able to bring that out during pretrial hearings where there are questions about the role, whether you're qualified to render an opinion because you are just a nurse. This very notion that diagnosis and treatment is in fact a part of the actual definition of nursing. And then from there, building on the definition of nursing are the scope and standards of nursing practice. And for the nurses on the call, this should look strangely familiar, going way back for many of you on this call to your earliest semesters in nursing school. Because the scope and standards of nursing practice describe who, what, when, where, and why of nursing practice. These are the authoritative statements that describe the responsibilities for nurses. and talk about how we are accountable and the related components of the nursing process. And that's the assessment, the diagnosis, the outcome identification, the planning, implementation, and evaluation. It's important to be able to describe all of this because, again, it underscores the basic guidance that exists for all nursing practice. And SANE should be able to describe that guidance that creates the foundation for nursing practice, since it does underscore the consistent foundation upon which all SANE practice is ultimately built. And then going from there are the specialty areas of nursing practice, of which forensic nursing practice is one of those. And we use the American Nurses Association template to create the specialty scope and standards for the work we do. And it describes, again, the who, the what, all of those sorts of things. It talks about the responsibilities for which we are accountable, provides direction for forensic nursing practice. And once again, we have to be able to describe that these scope and standards build on that general nursing scope and standards to identify the left and right limits of the work that we do. All of this underscores the role of our work as a healthcare role and makes it clear that we are expert clinicians and not just forensic evidence technicians. And then really finally, one of the cornerstones of establishing your expert nursing credential is understanding your State Nurse Practice Act. And I encourage you, if you haven't looked at your State Nurse Practice Act in some time, to make sure that you review it, because one, you need to know what your State Nurse Practice Act says, if anything, about your work as a sexual assault nurse examiner, because you certainly can be questioned on that. But two, you do want to know what it has to say about things like diagnosing if you are a nurse. And you can see on this slide highlighted is Colorado's definition, because Colorado has a beautiful definition of diagnosis within the State Nurse Practice Act. So if you're lucky enough to live in a state like Colorado where you have this beautiful definition, it should be highlighted as part of your foundational testimony so that it's clear that diagnosis and treatment is a fundamental component of the work that you do as a nurse, so that if you are drawing an objection for being able to render a particular opinion because you're not qualified to, say, diagnose and treat, you're able to highlight that, in fact, you have this underlying guidance which clearly states that you can. So, you know, my mantra has always been that ultimately, when you are getting ready to take the stand, you have to be prepared to be able to defend your practice. And in order to be able to defend your practice, you have to create a defensible practice to begin with, which starts long before you ever get a subpoena. And in order to have a defensible practice, you have to have the answers to two very basic but critical questions. How do you know what you know, and why do you do what you do? And the answers to those two questions must be so much more than because that's the way I was taught, because that's what our protocols are, because that's the way we've always done it. Those kinds of responses will not support or protect you on the stand. These types of questions need to be grounded in the state of the science, in the accepted practice standards, and in your own clinical experience. So when you're thinking about why you use toluidine blue dye to identify injury, why you use alternate light source, why you do the things you do to take care of patients, you need to be able to draw upon the practice standards, the science, and your own experience to be able to answer those types of questions. Being able to do that will then allow you to cogently answer questions about your practice and defend challenges to your practice when you are on the stand, when you are being questioned about your opinions in court. So let's take a look at how this works. All right, so you are the treating clinician. You get a subpoena from me, the prosecutor, and I say, hey, I'd like you to testify. And by subpoena, I mean you're going to testify. Okay,
So what I want you is to testify to what you did in that case. And so I'm getting ready, I list you on my witness list, and then all of a sudden, I get a pretrial motion. And that motion is from the defense, and it says, Jennifer Markowitz should not be allowed to testify to the use of TV dye because either she's not competent to testify to it, or the use of it is improper, or it's not scientific, whatever it is. Basically, we're on notice that we have a Daubert hearing. So here's what happens. I call you up and I say, hey, we're going to have a Daubert hearing. And now you know what a Daubert hearing is because we talked about it. It's the name of the dude who was in trial. That's how all these things work. A Daubert hearing comes from the title of the case. Now here's the nice thing about a Daubert hearing as opposed to trial. You get to bring all your stuff with you. Your smart book gets to come with you. All of the science that you've ever accumulated on a particular topic comes in. Because at trial, it generally doesn't. We generally expect that you're going to testify from your memory, unless it's incredibly complex information. So maybe you say to me, but I don't have a smart book on TV dye. Well, okay, that's all right, but you may not have that much time to go get the science. So let me start off with Jennifer and ask you, where does one go to look for this?
Well, I mean, I think first of all, there are a couple things that you can do. I mean, one is if you are going to have to testify to this science, it is best to do your own literature search. You want to think about what your question is, what do you need to know, and then you need to turn to an electronic database, and I use PubMed, and you type in your key search terms so that you're familiar with sort of the spectrum or the breadth of the research, because you need to be able to speak to that as we're about to demonstrate.
So while I love that answer, is there anywhere that there is, for instance, a bibliography on science? So bruises, strangulation issues, any of that?
Yes, you're lovely, and that was a softball. So the website that I run, forensichealth.com, has a number of clinical guides. It's all free. It's all available, and there is one, as a matter of fact, on telluridian blue dye. So as we're talking about this, for those of you who are interested in this, it's all available to you right there.
So many of you are saying, hey, Sasha, I've testified to TV dye 100 times. Well, great. Nobody's objected yet. But someday somebody is. And maybe I picked TV dye because it's something that clinicians use so regularly that it was the easier thing to pull as opposed to something more complex. So that's why I would pick TV dye. I don't know if it will ever be the subject of a Daubert hearing. It could be. So we're going to walk you through what it would look like.
Yeah.
Now, we're going to do a really short and condensed version of it, but basically, here's what happens. You grab your smart book, it's got all your the peer-reviewed publications on TV dye. Now, generally, your prosecutor is going to know a lot about this issue, too, because we have to become competent to ask these questions so that we can argue them to the judge. So I'm going to probably ask you, hey, can you help me find some research on the use of TV dye or the validity of the use of TV dye to identify injury? So we set a court date, and I'm going to set you down. It's pretty informal. I mean, we're in a courtroom. There's a judge, and then there's the defense attorney and the defendant, and then there's me. And you've got basically a table full of all of your stuff on there. And so here's generally the way it works. It doesn't matter if we're talking about TV dye, subdural hemorrhages, retinal hemorrhages, whatever it is, this is the way it rolls. So I'm going to say, hey, Dr. Markman, what's your last name? What is TV dye?
I'm going to try to recover from that one, sorry. TV dye is also known as telluridian blue dye. Oh, I wish you could see what this looks like right now. Telluridian blue dye, which is a nuclear stain that's commonly used to detect and document genital and perianal injuries.
So how does it work?
It generally gets taken up into disrupted or abraded tissue and acts, I like to describe it, it acts like a giant highlighter so that it enables us to better visualize anogenital injury, superficial anogenital injury to the external genitalia.
So is that something that is regularly used by clinicians in this field?
It is a commonly used technique used in sexual assault medical forensic exams, yes.
So I'd like to talk to you a little bit about the validity or the science behind the use of TBI. Do you know if there are any medical or scientific studies addressing the validity of the use of TBI?
There are certainly multiple studies that have looked at the use of TBI in identifying anogenital injury from sexual contact, both consensual and non-consensual.
So a couple times you've used the word anogenital. Could you just tell us what that means?
It means we're talking about both to the genitalia as well as to the anal area.
All right, so I'd like to talk about one of those publications right now. Do you have one up with you?
I do.
And what's the one that you currently have?
In front of me, I have the comparison of methods for identifying anogenital injury after consensual intercourse.
Is that the name of the study?
That is the name of the study.
And where did you acquire this? What I want to know is this a published study?
Yes, it was published in the Journal of Emergency Medicine.
So the Journal of Emergency Medicine, what we refer to as a peer-reviewed journal?
It is.
And can you tell us what peer-reviewed means?
It means that it is an article in a journal that is generally reviewed by other experts in the field, held to certain standards that are set forth by the field.
Okay, so what I'd like you to do is actually just walk us through the findings of the study, if you would.
In a nutshell, this study found that the use of toluidine blue dye, or TB dye, was particularly effective at identifying anogenital injury in this study population.
And can you tell us whether or not there's like a statistical significance to the findings of this study?
The results were statistically significant, yes.
So how does that happen? How do you know that the results of that study are statistically significant?
They're calculated in p-values.
P-value, okay. Tell us what that is.
P-values are essentially just how trustworthy are the results. How do we know that those results are actually results we can rely on versus results that are simply from chance?
So fair to say then that you don't have something specifically like an error rate, meaning whether or not something gives you like a false positive in this type of specialty tool.
Correct. This isn't like drug testing where we can get, where we might have error rates. In this type of research, we rely on p-values to be able to give us statistical significance.
And that's pretty much for all clinical medicine, is the use of this p-value.
That's generally what we rely on, yes.
All right, so in assessing this p-value, tell us how we know something is statistically significant.
If it's 0.05 or less, we consider it to be statistically significant.
So then I guess in other words, if it's not 0.05, then it's not statistically significant?
If it's greater than 0.05, then it's not statistically significant.
And so what are we concerned with then if it's greater?
That we have findings that could have been from chance, essentially.
Okay, so we can't rule out chance being a contributor. That makes sense. All right, so in this particular study that you told the court that validated the use of TB dye to assess injury, what was the p-value?
The p-value was less than 0.05.
And so again,
0.05.
So 0.05 then means that it's statistically significant.
That's correct.
Are there other journals, are there other publications addressing the use of TB dye?
There are.
So here's what I would do now, right? That's one. I would probably, and this is me, I'm pretty hyper-technical when it comes to doing hearings like this, and so I want to make sure that I've, one, created a really good record that is going to help the judge not abuse his discretion. That is, I've given him or her so much information that they are confident that what I'm going to have my expert witness testify to is valid and reliable, because that, after all, is the Daubert standard. I've clearly met the relevance threshold, because relevance is an initial determination, which is that what I'm going to have this witness testify to helps prove or disprove a fact that is important for the jury. So, for instance, in this case, Jennifer, correct me if I'm wrong here, but if we found something based on the use of TB dye, then generally we're saying there's been some trauma to that tissue. Accurate?
It is, with the caveat that it's been used and applied appropriately.
Fair enough. So assuming that it's been used and applied appropriately, then there being findings as a result of that might tend to prove that there was trauma to that surrounding area. True? Sure. Okay. And then, of course, for me, the broader issue is, assuming I've got a sexual assault allegation, I'm charged sexual assault, then what my victim is saying to me is that so-and-so penetrated me either digitally or penilely or with some object or something, and so that tends to prove that particular account of what happened. And so that's what we're doing here. And so I'm just trying to show that the use of this TB dye is valid. So that's one study. I'm going to walk through 8 or 10 of them until either the defense says, Your Honor, we withdraw our objection to the validity of this tool, or I'm satisfied that the judge has enough information. Now, here's the flip side of this. All you heard me do was the direct examination. And again, this is an adversarial system, which means the other side gets a crack at you. And you can be certain that they also have an expert witness available. I guess I can't say you can be certain. My hunch is they've got somebody available. Either they have talked to somebody ahead of time or they actually have somebody sitting over there with them. So they're going to cross-examine you. And if you cite a study, you are responsible for knowing the entirety of that study, which means if the methodology was all dorked up in that study, you have to know that.
I think that's such a good point because, you know, a lot of times when we're talking about knowing the science, for the nurses on the call, it's not enough to just look at the abstract and pull out the numbers in that abstract. You really must know the methodology, the science, all of that. And so if you are not familiar with reading and understanding research, this is one area of the profession that you need to spend a little bit of time getting proficient in. And certainly reach out to your colleagues who have that knowledge. There's a good clinical guide on the Forensic Health website on understanding research. It has how to conduct a literature search on there as well, and I encourage you to think about carving out the time to learn how to do that because it is a part of the professional responsibility of the forensic nurse to be able to do that. And just reading the abstracts is sadly not enough for those of you who find research to be a little bit of a teeth gnashing exercise. So a little point, though, to sort of bring down some blood pressure. You're not in front of a jury, which means the judge is less concerned with economy of time than ordinarily we would be if a jury was present or an actual trial. So let's say you get a question on cross-examination and you don't know it off your head. You can take the time to look at it. And all you have to say is, may I take a moment to pull that up? Now, can I control whether the other side gets uppity on you or not? No, but the judge is probably going to let you take the time to look at it, and if not, the prosecution ought to be able to rehabilitate you on redirect and give you the time to look at that, and that's okay. Now, if the other side cites a study that you're unfamiliar with, and they're going to cross-examine you on that, hey, Miss so-and-so or Nurse so-and-so, you just talked about these 5 pieces of literature, but aren't you familiar with this piece of literature that says blah, 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 blah? Well, nobody expects you to be a walking encyclopedia of medical research. So you can say, you know what, I'm not, but I would be happy to take a look at it. And so you do that. Now, do not say when asked, how long would it take you to look at that, 20 minutes? And you say yes because you're really worried about looking silly. No, no, no. You can't look at a scientific study in 20 minutes. Say, you know what? I'd love to have an hour, 90 minutes to take a look at it. And the judge is probably going to give you a recess to look at it. So do take a look at it and be ready after that time. All right, so that really covers Daubert. I think in a good enough way, and then of course we'll take your questions at the end if you have anything more specific you want to know about Daubert. So we're going to move on to hearsay at this point. Another challenge to your testimony is going to be
what the patient said to you. Because if you go back to the beginning, I said generally, as a prosecutor, I want 4 things from you. And oftentimes, I want statements that the patient made to you during the examination because so much good information comes from that. So, again, anybody who's watched A Few Good Men or any other legal drama knows this word hearsay. But what does it actually mean? So, in general terms, hearsay is any statement not made in court that day. Or said differently, anything that was said prior to court. And again, there are rules that govern what come in. Again, our touchstone here is relevance and reliability. Because not everything ever said gets to come in. Only things that are going to help a jury decide a particular fact that they're worrying about or struggling with is going to come in under the relevance threshold. The second thing that we're interested in hearsay is the reliability. And this dates back to like old English time here. I don't need to get into that. But, you know, basically the Spanish Inquisition and things like that we're concerned with. So that's why reliability really becomes a factor here. So I put up the formal fancy pants federal rules definition up here. But basically it's any statement not made in court that day. Now there are a ton of exceptions to hearsay, so much so that oftentimes the exceptions swallow the rule. So in the federal rules there really are more than 20 exceptions. But I really only are going to focus for this group on 4. And for my prosecutors who are listening in here, we oftentimes find ourselves immediately going to the medical hearsay exception, that is statements made for medical diagnosis or treatment. And that's because we immediately correlate, well, this person was in for medical diagnosis, therefore it needs to fit under there. But you know what, there are some things that happen in court or before court that may render that particular exception unavailable to us. And when that's the case, we don't just lose all of those statements. We have to really be smart about figuring out where else we can fit those in. And oftentimes, that can fit under present sense impression, excited utterance, or then existing mental state. So I'm going to spend just a few minutes going over that, and this will actually help the clinicians too, because when I say to you, and this is, let's assume we had pretty poor pretrial prep and you're on the witness stand and I'm giving you the knowing look of please God help me with this response because the other side objected, and I say, can you describe what the patient looked like and sounded like when she said that? And what I'm praying for is that you give me words that are going to meet my legal foundation here. But it's not fair to you because you don't know that. So that's actually why we're going to spend some time talking about that. Now, just so you know, now, anybody who's ever listened to me before knows I have never advocated for you to change your practice to please me, the prosecutor. I always argue the opposite. I don't care if you make my life more difficult. It's my job to win cases, not yours. And at the end of the day, what I always say is, if you just do the best clinical job you can do, my job is so much easier. But I want to just give you the legal foundations for this, just so you know when we give you that please God help me look. So most of the time you're familiar with medical hearsay. I'm going to get to that in a minute, but I want to go through a couple of these other ones. So present sense impression. These are all the exceptions to hearsay. So the technical definition for a present sense impression is a statement describing or explaining an event or condition that's made while the declarant, that is the person who said the words, was perceiving the event or condition or immediately thereafter. Now, timing is really a big issue on this one. Again, that statement has to be made while the person is perceiving the event in their mind or immediately thereafter. So could it be that you have an acute examination and you palpate the patient's, I don't know, arm or leg, and his or her immediate response is, ow, that hurts, that's where he punched. That's what I'm looking at here. Now, could I fit that in under the medical hearsay? Probably, but again, maybe that exception is lost to us for other variables. It could fit under present sense impression, and that's because it's an acute examination, so it could be immediately thereafter, and it's a statement that was made while the declarant was perceiving the event, and that's because you palpated this particular area that immediately brought up this memory of the event that happened. And so that's when the patient is saying, ow, that hurt, that's where he hit me. So they're perceiving the event. And again, that's going to reliability. We want statements to come in that are not made with the idea that this could go to trial and somebody could use that. I mean, that's sort of a general statement. We want reliable statements. In a present sense impression, all these exceptions generally go to reliability. So the next one I'm going to talk to you about is an excited utterance. And you may not see a discernible difference between excited utterance and present sense impression, and in all reality, there isn't much. So the definition for excited utterance, it's a statement that's relating to a startling event or condition made while the declarant was under the stress or excitement caused by that event. This is where I'm generally asking you to give me the demeanor of the patient. Here's why. Oftentimes I have to do this with my law enforcement colleagues. So let's say, the victim runs out of the house screaming and says a number of things, and the police officer says, what happened, what happened? Now, I need to talk about what the patient or the victim, in that according to the law enforcement officer, looked like. She was screaming, she was crying, she was agitated. Those types of really good descriptors help me, because remember this definition. It's a statement relating to a startling event or condition made while that person was under the stress or excitement. Now, it doesn't have to be those over-the-top things, screaming, crying. I've had it come in with children who whispered or hid and cowered. So the antithesis of that is actually valid too. What we want to know is, can I link it to this person being under the stress or excitement of that event? That's an excited utterance. And again, time actually is important. It's a factor in that. How close in time from the incident, the abuse, the assault, whatever you call it, to the time that statement was made. So the third one I want to talk about is it's a long one, but it's called then existing mental, emotional, or physical condition. And the hyper-technical definition for that is a statement of the declarant, that is the person who makes the statement, of the then existing state of mind, emotion, sensation, or physical condition. It hurts. I'm tired. Those types of things. But it does not include a statement of memory or belief. I think he did this, or, and then this is what happened in the past tense. That's not what comes in. It hurts. I'm tired. My throat is bothering me. Those types of things can come up with that. Then existing mental, emotional, or physical condition. All right, so those are those three. And then I'm going to spend just a few minutes here talking about medical hearsay, because that's what oftentimes you see. So again, we're talking about reliability here. So it is a statement made for medical diagnosis or treatment. So in order to do that, we've got to have two things. One, the statement is made for and reasonably pertinent to a medical diagnosis or treatment, and it describes medical history, past or present symptoms or sensations, their inception or their general cause. How I got that bruise, maybe even at times who caused that bruise or how it was caused, those types of things. But again, it has to be made for purposes of medical diagnosis or treatment. And here's generally the issue on that. We believe that people are going to tell the truth when they're talking to somebody who's going to heal them or help them. And that's generally the idea of that, and I've just given you a citation for a case that specifically says that.
So you just have to keep in mind that, objectively speaking, your practice philosophy, for the sanes on this call, your practice philosophy is going to impact admissibility. If you see your role as a healthcare-driven role, it's going to impact admissibility in a way that is going to be different than if you see your role as much more an arm of law enforcement or much more of a forensic evidence technician type of a role.
Now, I certainly don't expect anybody in this room to remember a year or two out from the actual time that you saw the patient what they look like. But a well-documented chart is going to go a long way. And I know that in all charts, there's a portion on there that talks about the demeanor, and usually we get that alert ×3.
Alert and oriented ×3.
Yeah,
yep.
That. But somewhere else on there, if it becomes important, which is palpated, this particular area, and the patient winced and cried and said this. That actually might be, if it's relevant for you to chart it, it would be relevant for me later on.
So this is where it becomes important to not just be an injury documenter in terms of photo documentation, but to not forget to do things like document pain complaints and use pain scales and things like that that can be very useful in providing a full accounting of injury and the spectrum of injury and signs and symptoms.
So the last thing that we're going to spend time talking about today is Crawford problems, also known as Sixth Amendment Confrontation Clause problems, and how they intersect with medical testimony. Okay, so here's the Sixth Amendment. Now, when you hear somebody talk about a particular clause of the amendment, that actually is usually just one sentence or phrase in the entirety of the amendment. So I've got those portions highlighted here, the relevant portion, because a lot of things come out of the Sixth Amendment. But the Confrontation Clause is what's highlighted. So here's what we know. The Constitution says that in all criminal prosecutions, the accused, that is the defendant, shall enjoy the right to be confronted with the witnesses against him. Now, this comes out of like the old, I mean, I hate to go back to like Spanish Inquisition, but basically those types of cases where the defendant didn't actually even get to be in the courtroom, or the witnesses didn't actually testify, rather statements from witnesses came in without those witnesses ever having to be there. And so over the course of the years, the law has sort of ebbed and flowed on how we're going to construe this Sixth Amendment. Rather, what I mean to say is, what's enough to satisfy confrontation? And so for a long time, we used to use the standard called Ohio v. Roberts, but that has actually changed. And so we get what the Crawford decision. So Crawford came out in 2004. It's not that new. It's well over 10 years old. But we continue to tweak what we understand about that. In fact, just last month, I think the biggest Supreme Court ruling on Crawford since Crawford just came out. And I'll talk to you about that in a minute. So basically, I told you that the title of the case is how we get these things, Daubert, Crawford, right? So this is a Crawford case, and Crawford actually, again, is a murder case. And so it was about whether or not, we could use the statement of Crawford's wife against him, that sort of thing. And so here's what we get. Despite the fact that we were using this old standard that talked about indicia of reliability, the Supreme Court said, you know what? This is actually a procedural right, and we mean to apply that standard strictly, which is the accused gets the right to physically confront witnesses against him, period. So they opened this window and said, you know what, we're not concerned necessarily with every hearsay statement. We're concerned with statements that are called testimonial statements. And so basically what happened is anybody who makes a statement that the Supreme Court would deem testimonial, and I'm going to ask you what testimonial means here in a minute, cannot come in unless the witness is there to be confronted, absent a few tiny little exceptions. And that is because we believe the best way to test reliability of a statement is through cross-examination. Now, anybody on this phone call who's been cross-examined in a pretty tough way understands, I think in hindsight, the value of that. But you can understand what the Supreme Court is saying when it talks about the crucible of cross-examination. And so that's what they say, that the best place to test reliability of a statement is through the crucible of cross-examination, because they can be pretty grueling. So testimonial hearsay. If it is testimonial hearsay, it can only come in three limited circumstances. One, if the declarant is there to testify. And quite often, people get Crawford and hearsay confused. They say them as opposite sides of the same coin, and they aren't. So if a witness is available to testify, we don't have a Crawford problem. We have a hearsay issue. And we talked about some of the exceptions to hearsay. We don't have a Crawford problem. We only have a Crawford problem when the witness isn't there in court to testify. And so what we can't do is bring somebody else's statements in through somebody else. That's what we're concerned about. But again, only if that statement is considered testimonial. And I'm going to pause for a moment. I'll talk to you about testimonial. If it is considered testimonial, the other way we can get it in is, let's say that that witness is unavailable to testify, but maybe at some other pretrial hearing, for instance, a deposition, the defense had an opportunity to cross-examine them. Well, then we've satisfied the confrontation clause because the defendant did have an opportunity to cross-examine them. Just because they couldn't have the opportunity at trial doesn't mean they didn't, because a deposition really is a portion of the trial. And thirdly, if there is an exception, then testimonial hearsay can come in. The exceptions are very narrow, for instance, forfeiture by wrongdoing, which is to say that maybe in a stalking case or domestic violence case, the accused specifically made it so that the witness did not show up to testify. Now, there's a whole lot of case law that talks about the intent of it. It can't just be a DV homicide case. If it's a DV homicide case and the homicide was a byproduct of what happened, then the mere fact that the witness is dead doesn't necessarily clear the confrontation hurdle. But if we bring up enough information pre-trial to show all of the totality of circumstances that is domestic violence, then maybe, but that's on us prosecutors to get that right. But somebody who has, paid off a witness or threatened a witness not to show up, that might get us forfeiture by wrongdoing. All right, so what is this testimonial thing you keep talking about? I wish I could give you the best answer, but the Supreme Court historically has not given us great information. In fact, in Crawford, we were all left shaking our heads saying, what do we do? What does that even mean, testimonial? Here's what they gave us in Crawford. And this isn't to speak ill of the Supreme Court. It's just what they do. They only narrowly answer things. And we, the judiciary, that we figure it out as we go along. So here's what we know at a minimum is testimonial. Affidavits, things that are sworn to. Custodial examinations, which means when you're brought into the police station and the police read you your rights, or if you're a witness, they bring you down and they ask you questions. Those are formal custodial interrogations or interviews. Prior testimony, that is one that was subject to penalty of perjury under oath, assuming that the defendant didn't have the opportunity to cross-examine you. And depositions. Depositions are obviously made with the intent to satisfy testimony at trial. So those are the biggies that we got from the Supreme Court. But, over the years, the Supreme Court has given us competing definitions, and we just kept trying to figure it out. Some cases that I would refer to if my prosecutors were listening, Hammond, Davis, Giles, Michigan v. Bryant, those types of cases. Those really started to help shape what that was. So here's the bottom line for testimonial. If it was made under circumstances which would lead an objective witness reasonably to believe that that statement would be available for use at a later trial, that's going to be testimonial. So what we get from Michigan v. Bryant, which I think was probably the other most important case to come out of the Crawford line of cases, is a statement of testimonial if it was procured with a primary purpose of creating an out-of-court substitute for trial testimony. But we just got last month, June 18th, what I think is the most significant Sixth Amendment case to come out of the Supreme Court since 2004 Crawford, and it's called Ohio v. Clark, and that's actually based on a 3-year-old talking to his teacher about the injuries sustained on behalf of from his stepfather. And so it is such a beautiful opinion in that it gives us these great language. Obviously, I'm a nerd, and I think it's a beautiful opinion. But what we get from the Ohio v. Clark test is, one, statements about children, and basically what it says, and don't quote me on this, but it basically says a child, pretty much statements from a child aren't going to be considered testimonial because no kid understands the adversarial process or the courtroom system, and so they're not making statements with the idea that they're going to be used later at trial. So we get age as being a factor. The other thing we get from the Supreme Court is that statements to people other than law enforcement officers are generally not going to be considered testimonial. Here's what we say, quote unquote, statements made to someone who is not principally charged with uncovering and prosecuting criminal behavior are significantly less likely to be testimonial than statements to law enforcement officers. That's huge. That really changes the way that we have understood Crawford. I think what they did is open a door to so many other witnesses being able to testify in the absence of witnesses. So let's bring this back to Saint. So historically, we were not really able to get information in about what the patient said, did, or heard without the patient being available to testify him or herself at trial. But I think given the right set of circumstances, given some good pretrial litigation, assuming that we can show that the encounter was not done, or the questions asked was not done with the primary purpose of gathering information to go to trial, rather, and I'm going to let Jennifer speak to this a little bit more, was done with the primary purpose in mind of diagnosing and treating the patient, we're going to have significant, this is me pontificating here, I don't know the answer to this. I think we're going to have significant success in getting this information in.
And this is really when it comes down to being able to articulate that healthcare component of the work that we do, being able to talk about the health and well-being of patients versus the evidence collection process. And the onus is on healthcare providers, on sexual assault nurse examiners to be able to articulate that to the calling attorney, as well as to be able to articulate that in the courtroom.
So, our closing thoughts for this, if you've ever heard us talk before, it's you got to know the science, not just the clinicians, the prosecutors, you got to know the science. You have to be prepared to discuss it in detail and the facts surrounding everything that you did, which always goes back to our mantra that pretrial preparation is critical to success. And you know what? Bring it back to the basics. One, as Jennifer talked about, your foundation of your nursing practice, and for the prosecutors, bring it back to relevance and reliability. At this point, I'm going to close out my session and bring up the screen for questions and answers. So Callie and Jason, this is going to go back to you.
All right. To kick off the Q&A, I was wondering if you might weigh in on a discussion that was being had in the chat. It was suggested that an objection to diagnosis testimony will succeed unless the licensing authority specifically includes making a medical diagnosis in the scope of a license. And specifically, an RN has had objections sustained against her testimony on the basis that they can't make a diagnosis and therefore can't question the diagnosis that was made. So this all ties back into the scope and standards of nursing practice that you had up. So are we dealing with a nursing diagnosis and not a medical one there?
So first of all, I think it goes back to being able to know what your own state nurse practice act says about diagnosis. I think it depends on the specific issue. When we're talking about issues related to injury and things like that, I think it's different than when we're talking about diagnosing disease process and things like that. So I hate to give the standard, it depends, but I think the circumstances make an enormous difference in terms of what the issue is and what my response would be. I think the foundational issues, though, related to some of the basic components of what we're often challenged on are really end up ultimately not being a non-issue when it comes to things like diagnosis of injury, though. And it does go back to some of those fundamental, some of that fundamental guidance, like that contemporary definition of nursing. I don't know if that answers it because I wasn't privy to, we weren't able to see all of the conversation going on in the chat.
Well,
so it may be that if the people were having that conversation, Jason wants to email me directly, I'd be glad to look at the issue specifically and respond with a much more well-reasoned response.
That's wonderful. I appreciate that, Dr. Markowitz.
Absolutely.
Moving on to a new topic, taking a look at hearsay. One of the participants was wondering about the admissibility of statements made by the parents of a child for the child's medical diagnosis.
So that brings up an issue that's called hearsay within hearsay. And there's not a categorical rule that statements heard by other people can't come in. What we have to do is find an exception for each level of hearsay. So when I'm doing an analysis of if I think I can get hearsay within hearsay statement in, I start at the root of the hearsay statement. So in this case, it would be the child, right? So if the child had described to the parents what happened to them, what they're feeling, then I probably am going to get an exception to the hearsay on that, depending on Many states have basically a first outcry exception or some sort of child hearsay exception. So probably that is going to meet the mail for that first level of hearsay. But now we've got to deal with that second level of hearsay, which is that the parent said it. And who did the parent say it to? So I hate to give you that really lame lawyer response of it depends, but truly it depends on the variables in there. Now, as I'm sitting here thinking, I have to tell you that I have a hard time thinking about a way that that's going to be able to come in. But it's absolutely possible. If you change the facts, I could see that. But the bottom line for hearsay within hearsay is each level of hearsay has to meet an exception.
All right. Also, considering the admissibility of evidence, and hopefully I'm going to get this question right, under Daubert or Frye, can you address generally what happens when the science changes? And the example given, I can't give any more than this, but the example given was 2015 Adams guidelines.
And I assume you're talking about Adams classification. Is that what we're talking about with children?
I'm going to say yes.
Yeah.
Yes.
Okay. Yes. Okay. You want to? No. So can you? I'm sorry, Jason. Can you repeat the question? There's like all these things going on the screen. We're getting.
What happens when the science changes?
So is the question related to have you testified to that?
Well, let me start.
Yeah, I think so.
Karen, while you're writing that in there, okay, let me start with this. Science changes all the time. And so what used to be admissible pretty pro forma may one day not be admissible. Maybe you've testified for a long period of time that this is the way we do stuff and it was valid. But all of a sudden we get new information that changes that. And you know what? We just address that change where it's relevant.
Yeah, I mean, one of the reasons why I think it's important to, I get a lot of requests for people asking for just specific articles. And one of the reasons why I encourage people to do their own literature searches is because I think you need to be able to speak to the evolution of the science. You need to know how the science has changed over time. It's important to know what has changed, where opinions have changed, so that you can answer the questions that may arise as the science evolves. We're a relatively young profession. It's not surprising that as research continues, we are going to have more information, and the science will inevitably change. So having the ability to do your own literature search and to continue to stay current in the field is imperative because of that evolutionary process.
So let me say this, because many people are well-seasoned professionals, and perhaps over the course of the years you've testified about science A being valid, and all of a sudden you get cross-examined on your previous testimony about saying that, science A was valid, and all of a sudden it's not. So I'm going to throw it to Jen and say, what do you do in the case where you're cross-examined on an issue on science that's changed, and you have historically said this is valid science?
Sure. I can think of, a really simple example. I've been doing this work for more than 20 years now, and some of you on this call have been doing that too. When we started doing this work, everybody thought a Woods lamp was a critical tool that we used. And I testified back in the 90s that, Woods lamp was an important tool. It was important for being able to, fluoresce stains on the skin. We now have science that makes it very clear that this is not a particularly sensitive or specific tool. My testimony on this particular tool has changed radically because the science has changed on this issue. I think that's just something that we have to be able to articulate. What has changed? How is my opinion on this changed? And be able to cite exactly why that opinion has changed.
So I think the best way to handle that, if you're cross-examined based on your previous testimony, you know what? You just say, you're right. The science that we had available to us at the time suggested and supported that this was a valid specialty tool or technique. However, the more that science and medicine evolves and changes, we learn, and based on the science in front of me today, I would have to say blah, blah, blah. There's just no way to clean that up or shine that up, and I think you maintain the most credibility simply by being objective and honest.
Yeah, I think that actually makes you a far more credible witness to be able to own both the limitations of practice as it existed and your maintaining currency in the research.
All right, Jason, any other questions?
That about wraps it up to the extent that we can answer beyond it depends. I do hate to ask you to back up, but would you be willing to go through your closing thoughts very briefly one more time?
Sure, and sadly I don't have that slide up, but here's generally what Jen and I always say. One, you have to know the science. It doesn't matter if you're the prosecutor or the clinician, you've got to know it. It has to be a part of your daily routine. I think the best thing to do for both sides is to create what I lovingly call a smart book. You just print out the stuff and you keep it, whether it's you're a digital person like me, you print stuff out like other people, whatever it is, just have it, write on it, highlight it, doesn't matter, and have that available. But you've got to know it and be able to critically read research and articulate it. The other thing I say is know your limitations. If you can't testify to the science, say that to the prosecutor, and we'll grudgingly find somebody else, but it's so much better than having you get up there and put yourself in a position where you cannot defend what you've done or what you've said. I think the other thing we said is a pretrial preparation is key. I can never say that enough. One, I have had a situation where I thought I had the holy grail of evidence. And the reality is when I went in and talked to the clinician, she said to me, that doesn't mean anything. And I was very sad about that. However, I learned so much by talking about what that issue was. So we learned so much from each other, and we help prepare our clinician for testimony so that they're in the best position to be able to defend their practice, to communicate effectively, and to ultimately successfully communicate.
No, I think that really says it. And I would encourage people, if other questions arise, they have our contact information, and I know that I'm happy to answer other questions on this issue as people think of them. So please don't hesitate to reach out.
But I would say this, because I happen to know where Jennifer lives and I'm in communication with her fairly regularly, send all of your emails directly to Jennifer and not me, because this is actually my last day at the National District Attorneys Association, so I won't be getting those emails, but I will get them from Jennifer.
All right,
so
thank you both.
Callie, we're going to send it back to you for closing remarks. And thank you, everybody, so much for your time, taking the time out of your day to spend it with us.
Thank you, everyone.
So thank you, Sasha and Jen, for a great presentation, and thank you to Jason for serving as our moderator. Here's some contact information for NDAA. Specific contact